Please share your PowerPoint presentation, sir.
Sure, madam. That is the message I got as asked disabled participants been sharing. I got the message requesting you to consider this and give me the rights to share. Yes.
Now you can share yours.
Yeah, madam. Now I can able to share.
Yes.
Super.
Shall we start now, sir? No.
Yes, madam.
Hello everyone, present here virtually. I am Nalini here and I welcome you all for today's session, which is titled as Introduction to Intellectual Property Rights. And presenting this session, we have with us our today's expert, Dr. Gautam Ashirwad Kumar, sir.
Yeah, thank you.
Yeah, just a minute, sir.
Yeah.
Dr. Gautam Ashirwad Kumar, sir, BTech MBA, FSI ESRP, PG Diploma in Education Management, PhD Assistant Professor in a Department of Management Studies, Bharata Institute of Higher Education and Research, Chennai. He has 6 years academic experience in a reputed institute. He also have 30 journals, 16 corpus and 3 UGC care listed and 11 UGC listed journals. He also published papers in various international conferences. He also authored 5 management studies books and 3 books chapter. He is having a 5 patents published. Without wasting much time, I welcome Dr. Gautam Ashirwad Kumar, sir. Now you can start, sir.
Yeah, thank you, madam. Good evening to one and all who is present here. I am Dr. Gautam Ashirwad Kumar. I am going to present on the topic of introduction to intellectual property rights. First, what is meant by intellectual property? So, what is meant by intellectual property? Intellectual property rights, IPR, are legally recognized exclusively rights to creation of mind. Intellectual property, which can also be acronym as a IP, which is refers to the creation of the mind, such as invention, literary and artistic works, designs and symbols, names and images used in commerce. It is a product of human creation. Usually, it is an intangible asset. So, intellectual property rights can be divided into 2 forms. The first one will be literary and artistic works, and the second one will be industrial property. So, what under will come under literary and artistic works? There are various types of books, paintings, musical composition, plays, movies, radios, TV programs, and other artistic work, which will be coming under the literary and artistic work. So, everyone will have the fear whether our work will be copied by the others. So for this purpose, the copyrights has been protected all these stuffs. So next is about the industrial property. Industrial property describes about a physical matter that is the product of an idea or concept for commercial purposes. So how this industrial properties has been protected? It can be protected by patented object, that is the invention can be patented so that it has been legally you can able to face in court if there is any copyright has been done, and by trademarks, by industrial designs, by trade secrets, layouts, and geography indications. Next is about the types of IP, that is in intellectual properties. So there are major three types of intellectual properties are there. The first one will be functional and technical inventions. And second one is purely and artistic works. And the third one is a symbol, logo, word, sound, color, design, etc. So under functional and technical inventions, it was be in a position to protect using the Patent Acts, which has been Patent Acts of 1970, which has been amended in the year of 1999 and 2005. And artistic work will be covered under the Copyrights Acts of 1957, which has been amended in the year of 1982, 84, 92, 1994, and 1999. And if you want to protect the symbol, logo, word, sound, color, and design, it will be protected under the Traditional Trademark Act 1999, which was amended in the year of 1994, 96, and 2000. Next is about the classification of intellectual property rights. According to TRIPS, which can be abbreviated as Trade-Related Aspects of Intellectual Property Rights Agreements, the intellectual property has been classified into various branches, and the first one is called as a patent. Second one is about industrial design. Third is about trademarks. Fourth is about the copyrights, and fifth is about geographical indications, layout design for integrated circuits, and the trade circuits. First, in this, we can able to see how the classification of intellectual property rights has been there, and how much time it has been valid, and whether registration is needed or not. For patent, it has valid for 20 years, and you need a compulsory registration in order to register your invention, because it will be made by the others as a for your work. So it has needs a registration. Once you have done the registration, means you will have the time of 20 years in order to renew that patent. So up to 20 years, it can be on the live. And next one is about the copyrights, which has 60 years, and registration is only optional. And next is about the trademarks, which is having a term of 10 years and renewable, and you can able to register or not. It is optional only. And designs about 10 plus 5, 15 years, which is a compulsory registration. Once if you have done a design, IPC design registration means it is valid for 15 years. And for trade secrets, as long as you have been kept within you, and it requires no registration. Next, for integrated circuits, if you have been done registration, it is a compulsory registration. It is the one-time registration is valid for 10 years. And after the 10th year, you need to do again registration, which is valid for another 10 years. And next is for the geographical indications, which requires 10 years of registration term. And if you want to further to continue, means you have to renew the registration process, and it is also compulsory registration. Next is about the patents. So the patent is originated from the Latin word "riter patens," which means an open letter. So it is covered under the Act called and Patent Act of 1970, which was amended by the Patent Act of 2005. It extends for whole of the India, and it is applicable to whole country. So we have what is regarded as a patent? It is actually a document which has been issued upon the application, either by the government office or by the regional office, which acts as an for several countries, which describes an invention and creates a legal situation in which a patented invention can normally only be exploited. Next, fees for registering or filing of a patent is the government usually takes the fees for filing the patent application in India is around 750 rupees for individuals. And if he wants to file any legal entities as a patent, means it costs about 3,000 rupees. So for first and second years, there's no fees. And for the next successive year, the fees has to be applicable. And renewal fees will be on the yearly basis required to be paid for 3rd to 28th month for keeping the patent in force. So every patent is valid only up to the certain years, in which if you want to renew the patent, means you have to pay the fees. And next, patent lapses if the renewal fees is not paid within the prescribed period. So if you're going to do any thing which is considered as a patent, which will be as patent, means you will first pay the certain fees of about 750 for individuals and 3,000 for legal entities. So it will valid for the 2 to 3 years. And if you want to renew, means you have to again pay the 750 to 3,000, or else your patent will be get lapse. So the next question that comes to your mind is patent granted in one country is enforceable in other countries? So probably the answer is no, because there is nothing like global patent or a world patent. Patent rights are essentially tertiary in nature, and also granting a patent in one country of the union does not force other countries to grant a patent for the same invention. So if you done any research, and if you got a patent and copyright for a particular thing, means in a one country. If you are saying India means, so if you're going to implement your work in the outside or foreign countries means, therefore there's not necessary to get a patent rights because you already got a patent rights in the India. So that's not necessary to get a patent rights. And next, refuse of patent in one country does not mean that it will be terminated in all countries. So from when comparing or moving out from one country to another country, each and every laws and regulations will be varies. So we can't able to predict that this product has been banned in this country and this product will be allowed in this country. So if you have been using the product that has been allowed in your country and it has been patented means it will be patented in all the countries. That is, it will not be terminated in all the countries and it has been patented. Next is about the objectives of a patent law. Usually this patent encourages innovations because only the pure research and the innovative ideas will be made as patents. So it has encourages an individual for the innovation and it offers protection for disclosure. It provides right to exploit commercially. It instills confidences in licenses, and there are variety of range of utility products are there which have been expected to emerge because usually the research can only be made as a patent. So if you want to do the patent means necessary there is a research has to be done. So if you're going to do the research means there may be new ideas that can be emerged from it and it facilitates an economic development. And next is conditions of patentability. So the first condition is about the industry applicability or utility. So the invention must be practical use or capable of some kind of industry applications. And next is about a novelty, and it shows some new characteristics that is not known in the body of existing knowledge in the technical field. That is, if you're going to do any research means probably you can able to implement a new concept in this. So it can able to give some novelty. So it's a second condition for the patentability. And the next one is about inventive step, that is non-obviousness. So it must show an inventive step that could not be detected by a person with an average knowledge in a technical field and patentable subject matter. The invention must fall within the scope of patentable subject matter. So if you want to get a patent means check whether that your invention has to be falls under the norms which has been prescribed under the patent office. And next is about examples of a field of a technology which may be excluded from the scope of patentable subject matter, which can include the discovery of materials or substances that has already been existed in nature, or the scientific theories or mathematical models, or the plants and animals other than microorganisms, and essentially biological process for the production of plants and animals other than biological, non-biological and microbiological process. Schemes, rules or methods such as those of doing business, performing purely mental acts or playing games. Next is about the types of patents. There are various types of patents has been available here. And the first one is about a product patent. The second one is about a process patent. So regarding with a product patent, it is actually a creation of a new product, which is, we can also call it as product invention. So example of this product patent is Pfizer company has got an patent on Lipitor, which is a new drug that has been invented by Pfizer and it was a patent. And next is about a process patent. That is the invention of a new method or process of making a known or a new product is called an invention. So example for a process patent is novel process for the extract of ashwagandha. And next is about the rights conferred by the patent are not described in the patent itself. So those rights are described in the patent law of a country in which the patent has been granted. The patent owner's exclusive rights generally consist of the several conditions which have been given below. And in the case of a product patent, the right to prevent the third parties without the owner's consent from making, using, offering for sale, selling, or importing of the goods. In case of process patent means you can easily able to get the patent directly. Next is about the example for a neem patent. That is, there are more than 40 patents which has been based on for this neem pesticides, which was the research has been conducted in the laboratories in United States and United Kingdom. So a US company, W.R. Grace, was granted a patent for neem, which can be used, you can able to use the neem as an pesticides. So India has granted more than 80 patents for neem. That is, the research has been done more than 80 with respect to the neem. And next one is about Tremor, which is called as an AIDS drug. So Cipla is a company which has been Mumbai-based company, which is a AIDS drug manufacturer, has patented its 3-in-1 combination antiretroviral ARV tablet Trioman in South Africa. So the company is also seeking a patents in 17 other countries, namely South Africa, which is the epicenter of the AIDS pandemic. So Trimon contains a fixed dose of three generic drugs, nevirapine, stravudine, and lamivudine. So these are the drugs which has been manufactured under Trimon, and it has got an patent. Next is about the cow urine patent, which is already patented in United States with a patent number of 6410059, which is a pharmaceutical composition which contains an cow urine distillate and as an antibiotic as bioenhancer was granted to CSIR, that is Council of Scientific and Industrial Research, for the further process. Next is about the copyrights. The Indian Copyrights Act 1957 governs the system of copyrights in India, which was amended in the year of 1982, 84, 92, 94, and 99. So why we need this copyright? If you are doing any research or anything that has a novel concept, means you are going to probably get this copyrights in order to protect this invention from others. So it is the right which grants protections to a unique expression of ideas. So what and all we can able to do in copyrights? The first one is about the literary works. Next is about the films. Next is about the dramatic, musics, artists, and sound recordings. These and all can be copyrighted. You can also have another question that what and all will not cover under copyright, that we can able to see in the next slide. So the topics which are not covered in copyrights are ideas, facts, recipes, work originality, and name and title or short phrases. So because this and all will be unique, which has been be differ from one individual to another individual. So this and all will not be covered under the copyrights. Next is we can say about the registration procedure for copyrights. So in order to find the copyrights, what are the procedures that we need to follow? The first one is you have to register the copyrights by completing a application form along with the appropriate fees that has been prescribed in the website. And you need not be in a position to send a copy of your work, because only the application form has to be filled in the initial stages. Later on, it can be move on to your work. So it may be appear with the same title, but if each work has been created independently, each will have its own copyright protection. Another question that will comes to your mind is, you are going to do a research in multiple areas, and if you can ask the question that if you are able to be in a position to get one copyright, will it be able to protect all other works? Probably the answer is no, because for each and every work, you need to create each individual copyright. So next we can see about the duration of the copyright. If you got a copyright at first, how much duration that it has been valid? So for the author's lifetime plus 50 years from the end of the calendar year until which the author has been expired. So 50 years has been given for films and sound recordings. 25 years has been given for typographic arrangement of published editions. And copyright protection will always be expires on December 31st of last calendar year of the protection. After this, you need to be renewed. So what are the actions that has been, next we can see about what are the actions that has been taken against the copyright infringement. So for a copyright infringement, usually we have seen about that is a work that has created any reproduction of work which has been created without using the permission of owner, and then remedies for the patent infringement. So if a patent has been copied, means what are the remedies that we can able to see is a suit can lie in a district or high court. It may issue an injunction either to prevent the infringer from any further use and award damages to the patent owner, or they will pay the patent owner royalties for further use. So if you are going to overcome or overclass from the rules and laws by making the patent other person's patent to use, means they will be in a position to pay to the patent owner as a royalties if they wants to use. Next is Apple has sued an HTC over the iPhone patents. So a suit can lie in the district court or in the high court of 63 of the Copyrights Act of 1957, which has been punishable with the imprisonment of 2 to 3 years and be fined as per the claims that has been given by the Apple. Next is remedies for copyright infringement. The remedies is a suit can lie in the district or high court. You can able to put the case, and it may issue an injunction either to prevent the infringer from any further use or to award damages to the patent owner, or will pay the patent owner the royalties for further use. So Actually, the problem is everyone will make the copy of the other ones. So in order to overcome from this, the research will be gets patented. So in spite of getting the research patent, and further, if anyone is individuals using this means, they will pay the some amount of money to the one who has invented, or the loyalties for their use. At last, I need to conclude that in this society, everything has been copyright, that is copied from one person to another. It is mainly due to the technological advancement, which has makes an creator very much easy to copy from one thing to another. So it is also made the job of copier easy, because he is just copying the one's creation idea and make it to implement in the real life. So everything, if you are going to do research, or if you are going to invent any new ideas, means ensure that you have been get patented for the object in order to avoid it legally for another one to copy your ideas. Yes.
Thank you so much for this very nice session, sir. If anyone has any question, you can ask.
Dr. Gautam sir, it was a very interesting and insightful session.
Yes, sir. Thank you, sir.
We are very thankful to you for the wonderful knowledge sharing session that we had. Thank you.
Thank you, sir.
Okay. Thank you so much, all the participants, for your active participation. Let me inform to all that this complete session will be available on our Business Rozgar YouTube channel. So if you want to watch it again, or want to share it to somebody, please do visit the Business Rozgar YouTube channel. And thanks. And last but not the least, thank you, Dr. Gautam Ashirwad Kumar sir, for
Yes.
taking out time for session. With your permission, I would like to end today's session here, sir.
Sure, madam.
Thank you.